After you've been treating for your work injury and you've undergone all of the therapy, all of the chiropractic, the acupuncture, the injections, perhaps even surgeries, at some point, the doctors are going to start evaluating you and giving opinions that is going to affect your permanent benefits under workers' compensation, your permanent disability benefits. If you don't agree with those determinations, eventually you may find yourself going to a workers' compensation hearing and litigating your permanency. We're going to talk about what it takes to fight for permanent benefits, your permanency hearings in workers' compensation. Hi everyone, my name is Britton Morrell. I'm an attorney with Kaplan Morrell. We've been helping injured and disabled workers in Colorado since 1995. We would love to be able to chat with you, talk with you. So if you or someone you know or love is affected by a work injury, please give us a call. You can write us, you can call us, you can text us. I'm going to put all the information there for you to be able to get in contact with us. And with that, let's dive into it. After the doctors give you all the care that they can think of that's going to get you better, they're going to come up with a number of opinions that is going to be used to determine what sort of compensation you as an injured worker get for your permanent disability or permanent impairment. There's a way to fight what the doctors give you, and so eventually that might lead to you going to a workers' compensation hearing to litigate your permanency. And we're going to talk in this guide to litigating your permanency in workers' compensation, the types of hearings that there are, what you have to kind of prove up your case, what are the limitations of those hearings, and then finally I'm going to give you some ideas of how successful challenges are in permanency hearings in workers' compensation. There are two broad categories of fighting for permanency in workers' compensation. You can either fight your impairment rating, or what's called permanent partial disability, or you can fight for disability, permanent disability, called permanent total disability benefits. Now you can do both at the same time. You can fight both the impairment rating and fight that you're permanently disabled, but they're two different kinds of arguments and proofs required and witnesses, etc. So let's first talk about fighting the impairment rating. In workers' compensation, there are three types of hearings that you can have to fight an impairment rating. Number one is you could be fighting the points. You know, the doctors say it's a 10% or 15% or 5% or 0%, and you think it should be more than that. It should be 20%, 18%, 17%, because an impairment rating, as we've talked about in other little clips, is a percentage. It's 5%, 10%, and it's based upon a guide determined by the doctors, and then that number is put into a formula depending on the body part that you've injured, and out comes a value, and that's what they're going to pay you. So there are two types of fights over trying to get more points of impairment. The first kind of fight is if you've injured your torso and other parts of your body. Those are called whole person body parts in Colorado workers' compensation. So if the treating doctor, the authorized treating physician, the company doctor gives you 5%, you think it's low, how do you fight it? Well, number one, you first have to go to a division IME. That is not going to a hearing, that's not going to court. You are going to another doctor for a second opinion. And that is a prerequisite, meaning you gotta do it. You can't even go to court to fight in front of a judge for a higher impairment rating if you're litigating a body part that's generally in your torso. Neck, low back, upper back, head injuries sometimes, often are considered that. So you have to do a division IME before you go to hearing, okay? The second kind of fight the for more points hearing is a injury just involving your arms, just involving your legs, and those kinds of body parts are in what's called a schedule, a list in Colorado for people who've been injured on the job in Colorado. And those ratings get expressed or get declared in two ways. The doctor will say something like, okay, he has a 10% rating of the arm, which is 6% of the whole person. Now, if you are okay with accepting the scheduled formula, and we're going to get into the formulas in a moment, then you can go directly to hearing and fight for a higher impairment rating without going to a division IME. And then the third type of hearing for an impairment rating is you're fighting the formula. You don't agree with the formula that's being used to determine the value of your impairment rating. In general, when you're fighting the formula, there's two types of fights. Number one is you can say, hey, I've injured a body part which the insurance company says is on the schedule and therefore paid out less because of the schedule formula. I think it should be paid out according to the whole person formula. The classic example of this are injuries to the shoulder, where the insurance company says we want to use the formula that generally pays less, which is called the scheduled formula. This shoulder injury is just to the arm, and we can go to court without fighting the points. We're not fighting for additional points. We're just fighting what formula applies to your injury. That is called a conversion hearing, converting the impairment rating from scheduled to whole person. The second type of fight the formula is often to deal with mental, traumatic brain injuries, psychological injuries, etc. In workers' compensation, there is a different formula that is used if your injury is just PTSD, depression, etc. They're only going to pay out a certain amount unless either your depression or your mental impairment is due to a crime of violence or due to an anatomical change in your brain function. And so it is typically more advantageous for injured workers to be in that second category than the first. So oftentimes we'll fight, hey, was your injury due to a crime of violence? Was your injury due to something that anatomically happened to your head, your brain function? If we can show that there was anatomical changes, for example, you had a concussion and a brain bleed, we're going to argue any mental impairment should be compensated at the second category, which is the mental impairment due to anatomical changes, which typically tends to be more compensation for the injured worker. For impairment fights, what do you really need to show? Well, most of the time, it's a fight between the doctors. If you are trying to argue more points of impairment, you need to have another doctor's opinion that your impairment rating should be higher. In cases of whole person impairment, okay, so injuries to the spine, the neck, the low back, the torso, you'll have to come to hearing where a division IME has already occurred. Now, if you're going to hearing after a division IME, that means one of two things. Either A, the division IME went really against you and you're wanting to fight it, or the division IME went against the insurance company and the insurance company wants to fight it. And the legal lay of the land is completely different in those kinds of cases, because in those kinds of cases, the judge has to uphold the division independent medical examiner's opinion unless it can be shown by clear and convincing evidence that that doctor is wrong. Well, what's clear and convincing evidence? The way that I describe it is if you came home and your car was completely destroyed, totaled, and your teenage son was at the house and your spouse was at the house, and you said, what happened? And your spouse said it was your teenage son who broke or crashed the car, and it was your teenage son saying, no, it was really your spouse, it was really mom or it was really dad. Who are you going to believe? And I would hope that most of the time you'd believe your spouse. Think of the kinds of evidence that your teenage child would have to show you to be able to start doubting and thinking, my spouse, my child's parent is lying about who was driving the car. Think about the kind of proof that you may need. You might want to see, your child doesn't have any bruises, but your spouse has a lot of bruises where maybe they got hit. Maybe there's cuts or glass in the hair because when they hit the windshield and the glass went everywhere, etc. But your child doesn't have any glass or bruises or cuts and everything. Those are the kind of hard evidence that would make you start to doubt your spouse. That's the same standard. That's the same standard in that the judge is going to look at anybody trying to argue against the division IME opinion. And so it often comes down to what is the diagnosis, when were body parts complained about, are there documented symptoms and everything in the medical record, and in general, it tends to be a fight between doctors. Since 2020 through 2024, there's been 130 cases where people have been fighting against the division IME rating, and 80% of the time, the judges are going to back what the division IME says. So if you're doing a permanency hearing, you're in a much better position if you are defending you like what the division IME says compared to what the division IME doesn't like. And chances are, if you're fighting against the division IME, you're going to need to hire a medical expert to come in and testify and explain to the judge why the division IME is wrong. If, on the other hand, you have only injured your hands, your wrist, your elbow, your knees, your feet, it's what's called a scheduled injury, okay? Then you can go straight to a hearing after the treating physician has given his or her opinion. You can get your own opinion with a doctor of your choice. You can go to a hearing and go in front of a judge, and you do not have to do a division IME. And in those kinds of situations, the judge can decide who is more believable. Even if I believe someone 49.9% of the time, but there's somebody else that has 50.1 and it's just slightly more believable, the judge can go with that opinion. And so you don't have this standard that you have in whole person impairments where you have to overcome the division IME by clear and convincing. With scheduled injuries, you don't have to do a division IME, so you can just go in there and try to say, listen, my doctor's more persuasive, and if you win, you can do it. Again, what tends to be the factors in the fights? I mean, I usually would prefer, if I can, if my client can afford it, to go to hearing with a medical expert to explain to a judge why my expert's impairment rating is more persuasive, better than anybody else's. Weirdly, again, it tends to be this forensic review of the medical record. What was complained about when? What was documented? Who documented whether or not there was crepitus, whether there was ratcheting, whether kind of range of motion there was? A lot of times the fight depends on what body parts are or are not included. Because, for example, if you don't mention that your low back is hurting until 3 months after the injury, chances are it's going to get denied and they're not going to include it. And if you need to fight it, you need to say, hey, I did complain about my back. We need to find those records to see and show that you did, in fact, complain of that body part back much earlier than what the treating doctor thinks. So it tends to be a pretty detailed medical fight, and it's more of a fight over what was documented, what was said back at the start of the injury. What are some of the findings? What do the MRIs see? What do the EMGs see? What do the x-rays see? They tend to be, again, very clinical notations. What tends not to be terribly helpful in a lot of these situations is how the injury has affected your life. For example, whether you're working or not working due to the injury, whether tends not to be a big factor in these kinds of permanency hearings. If you have restrictions, same thing, tends not to be a big factor. It can be mildly helpful, but they're not opportunities where you can talk about how the injury has totally changed your life. And that's something that the judge can deal with, because we're dealing with an impairment rating. It's primarily based on diagnosis, kinds of surgeries, and loss of range of motion. So those are the two kinds of fights if you're fighting your impairment rating and you're trying to increase the points. But third type of fight is changing the formula. In general, for most workers, a whole person impairment formula is going to give you more compensation for not getting back to 100% than a scheduled formula. And the big example, as I've always used, is someone's shoulder. The insurance company is going to say it's an arm injury, arm injury, arm injury. We're only going to pay the scheduled formula. I'm going to argue it's a whole person formula, and I'm going to ask for that formula. And oftentimes it can make the difference between 2, 3, 4, even 5 times the compensation shifting from a scheduled to a whole person impairment. So how do you fight changing the formula? The law isn't terribly clear on when a scheduled injury can become a whole person. Basically, what the law says is if the impairment and the disability is the functional impairment is off the schedule, then it's okay for a judge to give a whole person impairment rating. Well, what does that mean? Oftentimes, it means, can I show there were pain complaints in the medical records to this part of the body. If you injure your shoulder and the pain is going up to the neck, I'm looking to see if that's been documented in the physical therapy notes, in the doctor's notes, etc. Worst case scenario, if I don't have it, my client can come in and testify about these problems, but we run into the problem that, well, this is what you're saying now, but you've been treating for a year and a half and you never complained of neck pain, etc. Second category of proof that can be helpful in converting an impairment rating are those stories, is how your impairment has affected your activities of daily living, your ability to do your job. Can you sleep? Does it interrupt your sleep? Are you able to reach overhead? Are you able to reach behind? Can you play with your kids? Can you do certain tasks or certain hobbies? That kind of testimony can be the basis for a judge to use a different formula to value your impairment rating. And finally, it can go to the doctors too. You can have doctor testimony talking about how various body parts that were between the shoulder joint and your spine, how those were affected and impaired, etc. And so therefore there's some anatomical basis to say there's an issues going on here, not just down here. So doctor testimony can be really important as well. The other category of fighting the formula is for mental impairments. And there's a formula: if you're depressed due to the injury or due to other things, they're going to try to cap or limit how much they have to pay for your mental impairment. However, that limitation doesn't apply if your injury was due to a crime of violence, even if the person who did the crime didn't have the intent to commit a crime. Classic example of this is for our nursing staff members, like our CNAs. They work at a nursing home. They're dealing with a patient who is delusional and starts biting people. Well, if they bite someone, it's not a crime because they're kind of delusional and they don't have the intent. In work comp, it doesn't matter. If it would be a crime of violence, regardless of the intent of the person doing it, then your impairment for mental impairment is not going to be limited by this cap on mental impairment benefits. You'll get the full value of the award. Similarly, if your injury, your mental impairment, is due to an anatomical change with your brain function, if we can show that, then you're going to get the better formula on there. That's litigating permanency as to impairment. The other kind of permanency hearing that we do is what's called permanent total disability, and that is for lost wages after MMI. Before MMI, all you have to do is show you have restrictions and you can't go back to doing your old job. After MMI, you have to show that you are so disabled due to your injury that you cannot earn, and I am using every word literally, you have to show that you cannot earn any wage in any position with any employer, anywhere, for any amount of money. If you can earn any wage in any position with any employer, anywhere, any amount of money, then I cannot get you lost wages after MMI. What does it take to go to hearing on a permanent total disability? I'm going to just give a brief summary. Basically, we need three proofs. Number one is I need to be able to show the judge what are my client's limitations, what are their restrictions. Number two, I need to show that my client has tried hard for work, has looked for work, has applied for work, and cannot get anybody to offer him or her employment in the competitive labor market. Finally, I also need what's called an vocational expert's testimony. So what's a vocational expert? A vocational expert is someone who knows all the jobs that are out there in the economy. What requirements do they have? Do they require, what kind of education, what kind of experience, what kind of physical capabilities? Do you have to speak English? Does it require repetitive work? And that vocational expert's going to interview my client, take into account their education, their experience, their background, along with the restrictions, and then give an opinion that probably not, my client cannot find any work for any wages. Obviously, the insurance company is going to get their vocational expert who are going to say there's all sorts of things that my client can do. And we're going to go in front of a judge and my client's going to testify about their limitations and how they've looked for work. The vocational experts are going to testify. Sometimes we have doctors come in and testify because my doctor is saying that there's higher restrictions. Their doctor is saying, no, there isn't. And it can be a long, for workers' compensation, fight. But that is the other kind of permanency hearing, permanent total disability. It is a huge fight. These hearings typically don't go to hearing. There's so much at stake that often they settle rather than go to hearing. But if you are looking at not being able to return back to work, then you may be looking at a permanent total disability fight in workers' compensation. Important thing that you need to know is workers' compensation claims are difficult, detail-oriented. You need an expert who has run this maze and continues to run this maze every day. And that's why we would invite you to call us if you or someone you know has been injured on the job, because these are the kinds of fights we do every day, and we've been doing almost every day since 1995, fighting for injured workers in Colorado to get the most compensation that they should get under the law for their work injury. And with that, thank you so much for spending part of your day with me.